Anytime you're in a relationship with someone and you think they may be cheating on you or being unfaithful, guess what? Maybe it's time to get out of that relationship. If you think that it's okay to hit someone else, maybe it's time for you to get out of that relationship. So I hope that you don't want any of your children to think that's okay. And you better start changing your ways.
So why should I continue him on probation? I don't understand. So I'm trying to figure out, why shouldn't I not just send him to prison?
We've got a defendant who apparently never learned how to keep his hands or his temper to himself. He walks into court acting like the laws don't apply to him, like he's got some kind of immunity card. But that untouchable act only works until reality slaps you in the face, and today's the day. The judge is done handing out soft lessons. You can feel the shift in the room, from patience to pure exhaustion. There's only so many anger management classes and probation extensions you can hand out before realizing this guy just doesn't get it. The system's about to show him what real consequences look like, so let's see what happens when "I'm sorry, Your Honor" finally stops working. Let's go ahead and dive in.
Charged with assault of a pregnant person, that's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Do you understand?
Yes, ma'am.
Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, state is proceeding on count 1, waiving and abandoning count 2, recommending deferred adjudication. There's an affirmative finding of family violence in the BIPP course. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand?
Yes, ma'am.
Next, I'm showing you outside the agreement. The state is recommending that your deferred adjudication be for 5 years, a TAP evaluation, no contact with Carissa, Karissa, Wilburn, Wilburn, parenting classes, $100 to an approved family violence center. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client has been on bond for quite a while, and he has also been working with CPS. They were involved in this case. We want to let the court know that he has done a one class that's a 13-week class. It's a San Antonio fatherhood class, Judge. We have a certificate that he can provide to his probation officer. He's in the middle of another program that he thinks is another 13-week parenting program. In addition, they have been working with CPS, cooperating and doing all the services to try to work towards reunification. I do not believe the mom has custody at this time. I believe another family member does, but they are currently working towards that. To that end, Your Honor, we would like to request if you would allow them to have, instead of a no contact order, a no harmful or injurious contact order with Carissa and the child so that they continue these services. They have been working for quite a while, and I have spoken with Carissa. She does want to be able to have contact with him and try to get the family back together, Judge.
Why is Child Protective Services involved?
Your Honor, when my girlfriend gave birth to our child, obviously we weren't in contact, but her mother called CPS services on her for some God reason because she doesn't want us together. So she got CPS involved and ended up taking our child away because
CPS just doesn't come and take a child because somebody got somebody involved. So what is the underlying?
Took the baby away, our baby away, because I guess Krista got into an argument with one of the CPS workers. So they told her that we're just going to take the kid away. I don't know because the fact that
I don't think John knows the allegations, Judge, specifically because they weren't having contact at that point. I think all he knows is he got contacted by CPS and they started working services, Judge. I think he doesn't know the answer.
Okay, because the explanation he was giving me are not
I don't know very little.
explanations.
I just said that at the beginning instead of wasting your time right there. But no, like I said, I the only reason why I'm involved with CPS is because they said that because I'm the father of Kinsey, then I was brought into this. No, originally CPS was called on her, not me.
Did I hear that right? He assaulted a pregnant woman? His own partner carrying his child? That's not just cruel, that's inhuman. You've got to be a special kind of heartless to do something like that. The disgust in the courtroom is instant. You can see it on every face, especially the judges. And then he tries to flip it, blaming his mother-in-law for getting CPS involved, like she's the villain here. Please, he attacks his pregnant girlfriend and then wants sympathy because someone called him out. That's delusion. Worse, he's lying with confidence, hoping the robe and gavel come with selective hearing. But when you've got CPS, assault, and a pregnant victim in one case, that's not a misunderstanding, that's a pattern. He's trying to spin the story, but no one's buying it. Even the judge's patience is running out, and you can feel it.
Okay, thank you, John.
Thank you.
All right, so that's still strange to me that they're having services done. Linda, do you know why services are being done?
I don't know, Judge. I should have probably asked her. I could probably get her to log in. But I do know that her mom does play a major part of this. She's been very vocal, and I think that's indeed why the no contact order was recommended, because the mom doesn't want them to have contact. But they are adults and they do want to get back together, and they have been trying to follow the rules now and do what's needed to be able to have a safe and healthy family.
Mr. Closton, if you drug tested today, what are the results going to be?
Your Honor, I have done drugs in the past. I'm starting to go clean. I don't know what they will be, but I'm
Well, let's do it this way. What could it potentially be?
cocaine, ma'am.
Okay. So I think that's why CPS may be involved in their lives. So, Mr. Closton, do you know whether or not your child was born positive for drugs?
Oh no, ma'am. I done a drug test with CPS. I'm just waiting for.
No.
Oh,
I'm not talking about you. I'm talking about when your child was born. Was your child born positive for any type of drugs?
No, ma'am. No, she wasn't. It's not. I don't do it like frequently. It just, yeah.
Thank you, John.
Okay. When's the last time you used?
But maybe a month ago. Maybe, yeah, about a month ago, give or take. A month ago.
So you shouldn't be positive for anything today. That's what you're telling me. Because if you used cocaine a month ago, your test will come out clean for cocaine.
Oh, I don't know. I don't know how long it lasts, but I mean, a month
No,
ago.
but I'm telling you, if you use cocaine 1 month from today.
Okay. Yes.
So, okay. 5 years deferred adjudication, affirmative finding of family violence, the BIPP course, and Ms. Corley, that course is going to have to be done because that's what's legislated. Parenting classes, if he provides documentation that he has completed a course that's comparable to the compadre parenting classes, that will be acceptable. $100 to an approved family violence center. Are you employed, Mr. Closna?
Yes, I am, ma'am.
What do you do?
I am a forklift operator.
All right, proof of employment within 15 days. There's to be no employment as a home health care provider or any employment involving minors. I'm going to want him to do the UA hotline, or either he can do a patch. I'm going to want a drug test tomorrow by 9 a.m. There's to be regular Zoom reporting or in person. If there's something wrong with your Zoom, you're going to have to report in person. There's to be no contact with Carissa Wilburn, and that's for now. I need to see how you're going to do while you're on probation. Ms. Corley, let's see where we are in 3 months. And if things are well, then I will allow him maybe to have contact. Rebecca, is there anything that I'm missing? Excuse me. community service hours. 120 hours community service restitution. 40 hours will be waived if you complete the COVID vaccine. I'm not forcing anyone to get the COVID vaccine. If you don't want to get it, you don't have to. But if you've already received the vaccination, then if you turn that in, that will count towards 40 hours of your community service restitution. Rebecca, is there anything else he needs?
Did you say CPS compliance if applicable?
Thank you. CPS compliance if applicable. And I'm going to want random field visits 2 times per month. Anything else, Rebecca?
No, ma'am.
Mr. Klosner, do you need anything else from this court in order to be successful?
No, I do not, Your Honor.
All right, we can go off the record. Mr. Klosner, here's the speech for you. 1, anytime you're in a relationship with someone and you think they may be cheating on you or being unfaithful, guess what? Maybe it's time to get out of that relationship. If you think that it's okay to hit someone else, maybe it's time for you to get out of that relationship.
This has to be one of the most toxic relationships ever dragged into a courtroom. Drugs, violence, CPS, and now a confession to using cocaine. It's like every red flag in one file. When the judge says it out loud, everything clicks. The erratic behavior, the excuses, the violence. He claims he's been clean for a month, but look at him. Shaking, sweating, twitching. That's not nerves, that's withdrawal or worse. And somehow, after all that, he still gets deferred adjudication. Basically, behave long enough and this charge disappears. That's meant for people who slip up once, not repeat offenders collecting charges like trophies. I get the rehab over jail argument, but there's a limit. How many times do you teach a grown man not to hit people? The judge is showing mercy again, but this feels like the same cycle on repeat. It's exhausting to watch.
You're supposed to love the partner you're with, and especially if they're carrying your child, because they're very vulnerable at that time. You're not supposed to put your hands on them in anger. Do you understand?
Yes, I do, Your Honor.
And if you're going to be the father of a child that a child will look up to, a father that a child will look up to, you can't be using drugs, because then you're teaching that child that it's okay to use drugs.
Yes, Your Honor.
If you abuse that child's mother, you're teaching that child that the way you show you love somebody is you abuse them. I don't know if you have a daughter or son, but let me tell you something. If you have a son and that's what they see, they're going to think that's how you show somebody love, on top of the fact that it's very traumatic for them when they see that. If you have a daughter and she sees this, she's going to think that the partner she's with, if that partner hits her, that's how you show love. So I hope that you don't want any of your children to think that's okay. And you better start changing your ways. And from here on out, everything you do while you're on this deferred adjudication, you need to ask yourself one question. Is the decision I'm about to make, could that potentially result in me going to prison for 10 years? You understand?
Yes, Your Honor.
All right, I'm going to send you to a breakout room. Probation will go over conditions with you. And if you want that no contact order for me to consider lifting it, you had better be spotless on this probation. You understand?
Oh, thank you so much. I hope everything is okay with, well, I don't want to say okay, but I hope everyone is doing the best they can.
Yes.
Okay. All right, I'm going to call 2021 CR 5795, State of Texas versus John Leal Klosna. Can I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense?
Adeli Silver for the defense.
Are you John Leal Klosna?
Yes, ma'am, I am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney?
Yes,
Did you understand it?
Yes, I did, ma'am.
Are you the same John Leal Klosna who was placed on deferred adjudication in 2021 CR 5795 for the offense of assault of a pregnant person on August 31st, 2021 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 7, on or about the 30th day of April 2023 in Wilson County, Texas. The defendant, John Leal Klosna, departed Bexar County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True, ma'am. The state will waive and abandon the other allegations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 7, the court could find it true, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 7?
Yes.
Court will find violation of condition number 7 true. Is there an agreement?
Mr. Honor, the agreement, should the court follow it, is to deny the motion and to alter and amend the conditions to add hostility and aggression management course and the family violence impact panel. And those, with those additional conditions, that is.
All right, why are we needing hostility management and anger course and family violence impact panel when he was supposed to be doing the BIPP course?
He has finished the BIPP course. It was finished last year. Yes, and then there's a new allegation of a new number 1 in Wilson County. It is still pending.
So why should I continue him on probation? I don't understand.
And just like clockwork, he's back. Shocker, right? Everyone saw it coming except him. Same story, gets chance after chance, swears he changed, then violates probation again. You'd think by now he'd realize probation isn't freedom, it's a test, and he keeps failing it. The judge looks done. You can see it in her face. I've seen this movie before. Sympathy's gone, excuses are dry, and even the courtroom staff looks tired of his name. He's sitting there scrambling for another out, but no one's listening. The question isn't if he's going to jail, it's for how long. And judging by the tension in that room, the answer is finally long enough to matter.
He leaves the county without permission. I'm not even going to consider the fact that there is a pending case in Wilson County because you all didn't go on that. But I do have the state and you all agreeing to hostility management course and the family violence impact panel live. So I'm trying to figure out, why shouldn't I not just send him to prison?
Well, he has completed many of the things that he had to complete, and he's only 2 years in, so he has 3 more years to go on his probation.
Why is he leaving the county without permission?
It was 25 minutes from his home. I mean, technically it still is out of the county, but it's 25 minutes from his home for a family function with his family.
State?
You're right. I think in the hostility and aggression management course, they do teach some different skills than you learn in the matters intervention course. And I think that maybe with these new skills, they could serve the defendant well and that he could complete the rest of his probation successfully.
All right. This is what the court will do. Is there anything you wish to say, sir?
Ma'am, I apologize for my actions and I won't mess up again. If you please can give me this opportunity to prove to you that I can do better, I will, ma'am.
All right, this is what the court will do. Court will deny the motion, alter and amend conditions to include hostility management course, family violence impact course live panel, and 10 days in the Bexar County Jail as a condition. All right, so you're going to go into custody today, serve your 10 days in the Bexar County Jail. And what you need to remember is you have to follow the rules of the court. Do you understand?
Yeah.
All right, so immediately upon your release, you need to get in touch with your probation officer, and you need to remember you're not allowed to leave the county. You understand?
Yes, ma'am, I do.
And you need to remember that the rules of this court are the rules of this court, because this contract is not between your attorney and the state. This contract is with the court. Do you understand?
Yes.
That had to be one of the weakest defenses I've ever heard. He really said he shouldn't go to jail because he's almost done with probation. That's not an argument, that's an admission. I'm shocked the state's still suggesting more courses after this mess. At this point, the only classes he needs is Consequences 101. Watching his face drop when the judge gave him 10 days in jail was pure justice. Shock, disbelief, that wait, you're serious look. As satisfying as it was, 10 days still feels light. Sometimes it takes more time behind bars to finally sink in. So what do you think? Will this be his wake-up call or just another short break before the next disaster? Let me know what you think in the comments. Thank you so much for watching. Don't forget to like and subscribe, and I'll catch you in the next one.